Chief Justice, and may it please the court. This is a voting rights case.
Baker v. Carr is a case about voting rights, but it's not about whether you actually get to vote or not. It's about how much your vote will count. The case arose because the districts for the Tennessee state legislature had not been modified since 1901. Originally, the districts were drawn up on the basis of population so that each district would have roughly the same number of people. But over the next 60 years, the population of various places changed. Some cities grew, some areas emptied out. So it got to the point where it was pretty out of whack, with some districts having big populations and some having far fewer voters. As a result, some people's votes essentially counted a lot more than others. Now, you might wonder why the Tennessee legislature would let it go this far and let things get so out of whack. They were supposed to do reapportionments every 10 years after the census. Why would they fail to get it done? It wasn't just a matter of being lazy or incompetent. Instead, there was an inherent reluctance to do the reapportionment because you need a majority of the legislature to do it. And the majority of the legislature was pretty happy with the way things were. They'd gotten elected with the way the districts were, and they weren't trying to realign the districts and rock the boat. In addition, there was a racial element to this. The portion of the population that was African American in Tennessee was a lot higher in the cities, especially Memphis, than in some of the rural areas of the state. So by increasing the voting power of the rural areas, you were effectively increasing the voting power of the white people of Tennessee and reducing the political influence of the African American population. An important thing to notice about Baker v. Carr is that they weren't actually deciding whether the Equal Protection Clause had been violated in that case. They were deciding a more preliminary issue, which is whether there was even an issue presented that was justiciable, meaning that it was proper for a court to decide it. Going all the way back to Marbury v. Madison, you had a passage of dicta in that case, that opinion, where John Marshall said that some issues are just purely political. They're subjects entrusted to the president or Congress and can never be examinable by the courts. That was the seed that grew into what is known as the political question doctrine. It's the idea that there are some questions that cannot be addressed by courts because they're to be resolved by the political branches of government, meaning the executive and the legislative branch. Over the years, there were a few cases here and there where the Supreme Court would say that something was a non-justiciable political question. The most common thing that got treated as a non-justiciable political question was things relating to foreign affairs, like the military and diplomatic relations with other countries. Courts tended to say that those issues were not justiciable matters, not things for courts to decide. So in Baker v. Carr, the issue was whether this sort of case about legislative districts of unequal population size presented a non-justiciable political question or instead just a regular legal issue that courts can decide. Before Baker v. Carr, the Supreme Court had treated disputes about legislative districting as being a non-justiciable political issue. For example, in a case in the 1940s, the Supreme Court had said that it ought not to enter this political thicket. In Baker v. Carr, the Supreme Court went the other way. It said this was a political case. It was certainly about political issues in some sense, but it did not involve non-justiciable political questions. It was something that was appropriate for courts to decide. There is an excellent series of podcasts about important Supreme Court decisions. The series is called More Perfect, and it has an episode about the Baker v. Carr case. I'll play some short excerpts here from it to give you an idea of what it's like, and I'd encourage you to listen to the whole episode if you're interested. It really is fascinating. The podcast tells all about the drama behind the scenes in this case, and it argues that the case essentially broke two Supreme Court justices. One of them was Felix Frankfurter, who was adamant that the Supreme Court should stay out of this matter. He was a liberal person, but he was a very strong advocate for judicial restraint, and he was furious about this case. And he had a very strong personality. Frankly, he was kind of a mean person, and he bullied the Supreme Court justices who were the swing votes on this to try to convince them to go his way. In particular, he was very hard on Charles Whittaker. Whitaker was a lawyer from Kansas City who attended the law school, now known as UMKC School of Law. And he was a fine lawyer, but he wasn't a big famous legal scholar like Felix Frankfurter. And he couldn't make up his mind about what to do in this case.
Okay, so after the oral arguments are over in Baker versus Carr, the justices head into conference. That's a meeting with just the 9.
And when they went into conference, basically the court was divided.
Right down the middle. And Charles Whitaker, he was a potential swing vote.
Whitaker was deeply torn.
He'd been leaning Frankfurter's way.
But
if there is a clear constitutional right that's being violated.
During that first argument, he asked a number of questions that suggested a great deal of sympathy with the plaintiffs.
Then is there not both power and duty in the courts to enforce that constitutional right?
There was a lot of thought that he might actually come down on the side of the plaintiffs in that case, and I think that's where Frankfurter really began to rip into him.
Justice Frankfurter, right after the first oral argument, during the conference, he gave a 90-minute speech. So talked for 90-plus straight minutes, darting around the room, pulling books off the shelves.
Pulling books off the shelf, reading from prior cases.
Gesticulating wildly to make his point.
And the whole time looking directly at Whitaker.
Frankfurter needed desperately. He had to get Whitaker. And he kept after him like a dog after a bone, trying to persuade him. And that harassing he got, I have to make a point here. It was a nightmare. And I saw the nightmare.
How so? Describe it to me.
Well,
he was a nervous wreck and like a cat on a hot tin roof.
I found out, I don't know if he told me or his wife told me, he was on tranquilizers.
To try to overcome what he thought was just work-related stress, well, clearly something was taking hold of him.
He had trouble concentrating.
Highly fraught.
I would characterize his eventual breakdown as something of a slow descent. By the early spring, after the court had returned from its winter recess, Whitaker was absent from the court.
He eventually just disappeared for a while. He didn't come back to work after the holidays. He went up to a cabin by a lake and just sat and was thinking.
You mean like he didn't show up for work one day?
Apparently so.
His clerks didn't know where he was. The other justices didn't know his whereabouts. He just disappeared, really in the middle of what's going to become one of the monumental decisions of the 20th century. He disappears. He had to escape.
Where did he go?
Well, he went to really what would be a cabin in the woods in the middle of Wisconsin. And he called up one of his former law associates in Kansas City to come up and join him.
And according to Craig Smith, he and this guy, whose name was Sam Mulby, they would just sit there on the bank of the lake in silence. After 3 weeks, Justice Whitaker returns to D.C.
Back to Washington for a few days.
That's Kentigin, his son.
We found my father to be really in extremis, debating, and I think borderline suicidal.
When you said he was suicidal, what do you mean?
There was an instance in which my brother found my father going upstairs to get a shotgun.
Oh.
Yeah.
Justice Whitaker wound up resigning from the Supreme Court. It didn't turn out well for Felix Frankfurter either. He wound up on the losing side of the case, so he is one of the dissenters here. And he was apparently just crushed by this. About 2 weeks after the decision was announced, he suffered a massive stroke. He survived it, but his health was so impaired that he had to resign from the Supreme Court as well, and he blamed the stroke on the stress of Baker versus Carr. Now, the decision in Baker versus Carr that this is justiciable is really just a very preliminary ruling, and it left the substantive issue still to be resolved. What does the Equal Protection Clause require in these situations? The Supreme Court answered that question in another case, Reynolds v. Sims, just a few years later. And the key rule from that decision has become known as one person, one vote. In other words, each district basically must have the same population as all the other districts, so that each voter has the same amount of weight given to his or her vote. The situation in Baker v. Carr obviously seems pretty unfair because some of the districts were much bigger than others. There were some districts, for example, that were 23 times as big as another, 23 times more people, and yet had the same number of representatives in the legislature. So I think it's not hard to see why the court wanted to do something about that. But in other cases, it was much less obvious that things were unfair. For example, there were some states that had bicameral legislatures, meaning they had two houses of the legislature. And in some of those states, one of the houses would be apportioned equally by population, but the other house would be apportioned in some other way, for example, with each county getting one representative. Those states essentially argued, hey, we're just copying the United States Congress. One house of Congress, the House of Representatives, is divided by population, but the other house, the Senate, is not. Each state gets 2 senators. So you might think if that format is good enough for Congress, then surely it's okay for state legislatures to copy it. But the Supreme Court said, no, you can't do that. It violates the Equal Protection Clause. The Supreme Court said that Congress is special. It was specifically created that way as a compromise at the Constitutional Convention. And it would violate the Equal Protection Clause if any state organized its legislature the same way. So the rule ultimately is one person, one vote, and every legislative district must have the same population. Obviously, it would be very hard to get it absolutely mathematically perfectly equal in every district, so it can be off by a little bit, but you have to make it as equal as you reasonably can. For example, there are cases where the districts are off by even a small amount, less than 1%, and the Supreme Court has said that that's not good enough unless there's a reason that you can't have more exact equality. One question that comes up when we say the districts must all be roughly the same size is, well, who do you count? Do they need to be the same in total population? Or is it the number of citizens that matters? Or people who are eligible to vote, such as they're at least 18 years old, they're U.S. citizens, they're not disqualified for some reason, such as a felony conviction? Or should you try to equalize the number of registered voters, or perhaps equalize the number of actual voters in each district? The traditional way of doing it is to make the districts equal in total population, so each district has the same number of human beings, or roughly the same number, whether they can vote or not, and whether they do vote or not. So that's how all states have handled it. Some voters in Texas recently challenged this, and they said that it was a violation of their equal protection rights for the districts to be based on total population. They said that it should be based on the number of eligible voters. The Supreme Court unanimously rejected that argument. They said that it was fine for the states to keep using total population. But they also left open the possibility that states could switch to using some other metric, such as the number of eligible voters. They said they'd address the validity of that only if and when some states started doing it that way. Baker v. Carr had a major impact on American elections and our political system. Earl Warren, who was the Chief Justice of the Supreme Court at the time, said it may have been the most important decision made during his time at the Supreme Court. He definitely participated in a lot of major cases, so that really emphasizes what an important decision the case really was.